All right, I do a fair amount of talking on this topic, as you might imagine, and each time I give a presentation, I kind of pull from my slide deck different slides that I think people might be interested in, depending on the audience, but we're not stuck to this particular deck, and if people have questions, I encourage you to ask them as we go along, and if we go off in some other direction and don't get through all the slides, it is what it is. I mean, hopefully we'll all still learn something helpful. So just by introduction, the Patient Protection and Affordable Care Act is 2,000 pages if you include the House bill. So far there's 20,000 pages of regulations that have been issued. A lot of the guidance is in proposed form, including the key guidance that affects employers came out in January of 2013. We're still waiting for that key guidance. It was about a 300-page regulation, described the so-called pay or play rules for large employers. And at this point, when the guidance came out, it asked more questions than it answered, looking for comments, and we don't have anything back yet from the federal government on what those answers might be. Most of you know that this particular rule, the penalties for employers, was delayed until 2015, in part because they didn't have the guidance out yet. And there's other provisions, however, are going to continue on track, including the requirement to pay some of these taxes that are going to go into effect. Already, for some employers, they've had to pay what's called a Bakke tax. It's a $1 per head tax on employees and their beneficiaries and their health plans. That was due July 31st for calendar year plans. In next year, we're going to have what's called reinsurance taxes, and that amount will be $65 per employee and every single dependent of the employee, and that'll be added to your insurance premium, or you're going to have to pay for it if you have a self-insured plan. So most of the concerns here are for what are called applicable large employers. And I know that not everyone here is an applicable large employer, but I think it's still, we'll talk about some concerns that affect small employers. And in doing business, it's always helpful to know what your larger competitors are facing and what your clients are facing that might be in this category. So I'm going to focus primarily on the impact of the pay or play rules for these larger employers. But again, we can talk about any other topic we want to here. In 2015, applicable large employers have to offer affordable health coverage. I'll get into the definition of an applicable large employer in a second here. The definition of a full-time employee is now 30 or more hours per week, and kind of a smart aleck comment, that's a 9-to-5 job with a 2-hour lunch break each year. The cost of expanding coverage or paying penalties will be significant. I guess that statement depends on where you are today and how much coverage you offer to your employees. What I found in addressing groups on this topic is that there's a pretty widespread use of part-time workers, of temporary workers, of seasonal workers, and a lot of workers that, in fact, might actually reach that 30 or more hour threshold, but don't have insurance coverage today. So we don't really know, and you won't know until you sit down and do the math, what impact this will have on your own business in 2015. In addition to the cost of either expanding coverage or paying these penalties, the proposed regulations came with this kind of incredible administrative scheme for counting hours. We'll talk about that a little bit as well. And it is going to be, it'll be something else. I think that the payroll function is going to become much more complex as employers begin to track these hours in the way that the administration wants you to track them. More likely than not, either your payroll provider is going to come out with a new product that's going to cost more to track this information, or you might have to hire someone to handle this function. For small employers who have group health insurance, and by small employers, I'm generally talking about 50 employees or less. Again, we'll get into more of that definition. It's really important to know where you fall on that line. health insurance costs are going to increase. And primarily, it's going to vary from state to state depending on what your state currently requires to be included in health insurance. Currently, the law requires that you cover these 10 essential health benefits. I'm not going to get into what those are, but by and large, the coverage is richer than it has been in the past. Deductibles in your plans for small employers can no longer exceed either $2,000 for single or $4,000 for family. Those rules are basically going into effect in 2014. Many small employers have high deductible health plans currently that are above that level. Plans are going to be community rated, and what that means is that every insurance carrier that sells small employer coverage is going to charge the same rate for every small employer. The only differences that will be permitted are based on the age of your employees, tobacco use, the family size that are being elected, and a breakdown by geography. So what this means is they pool the risk across their whole book of business for every small employer. And if you happen to be a small employer with a healthy workforce, you're going to end up paying a lot more than you might have had to pay in the past. If you're a small employer with an older, sicker workforce, you might end up benefiting at some level from this program. What's happening though is for a lot of small employers are considering and moving towards self-insurance at levels that we haven't seen in the past. Typically, we'd always advise employers not even to consider the risk of self-insurance unless you had at least 300 employees. Now we see them down to as low as 20 employees. And there's lots of different ideas for stop-loss insurance programs and different ways to manage that risk. But more and more we see smaller employers going self-insured, willing to assume that risk to avoid the additional expense that a fully insured type program might have in store for them. And then finally, there's a growth concern right at the 50 employee benchmark. They call these employers the 49ers. A lot of employers are not willing to expand their definition of full-time employees would be beyond 49, because once they do, they get into a whole new category of responsibility under the Affordable Care Act. So it might be an impediment to growth, maybe just a temporary blip for employers that are growing quickly, but it is one of these areas that people are managing more closely. Unions have concerns, and the primary concern for unions, I think, is large unions anyways, offer these Taft-Hartley plans that they are deeply involved in. It's one of the benefits that they offer to their own employees. They're worried that a lot of employers might, instead of becoming engaged in these Taft-Hartley plans, they might drop coverage and put their employees on the new federal exchanges. They're hoping that they could get subsidies themselves so that their workforce could be subsidized through these Taft-Hartley plans. That didn't come to pass. But the primary concern, this is a letter from James Hoffa, and it was co-signed by a number of other union members just a couple of weeks ago to the administration. They're worried about the problem of part-time employees, and the concern is that under the Act, employees are now defined as 30, or full-time employees are defined as people who work an average of 30 hours per week. As a result, a fair number of them employers, especially in the retail or service industries, are beginning to manage those hours down to below 30 hours per week. And that cuts into union dues, it cuts into union membership. And as James Hoffa said, it will destroy the foundation of the 40-hour work week, which is the backbone of the American middle class. Pretty dramatic, but you can see that these groups which strongly supported the legislation when it was passing in 2009, not all of them now are in favor of its continuance. So let's move on a little bit to the definition of who's an applicable large employer. It's really important to know, especially if you're on the cusp or you might find yourself coming close to this number. Basically, it's an employer who employs an average of 50 full-time employees, meaning 30 hours per week in the previous calendar year. And in determining the full-time employees, though, they also take into account full-time equivalent employees. So how they measure that is they take all their part-time employees in any month, they add up all of their hours for that month, and they divide that amount by 120, and that number is considered the equivalent full-time employee. So if you have a fair number of part-time employees, you do need to do that calculation. You add those employees to your actual full-time employees for each month of the year, and then you do an average at the end of the year, and you see, are you at 50 or not? Special rules allow you to exclude seasonal employees, and I won't get into that. We don't have time to get into the level of details, but generally, if you only exceed that 50 employee level for 4 months, and they can be any months during the year, and you exceed it because of seasonal employees, then you can exclude those individuals in determining whether or not you hit that 50 employee threshold. If you're a large employer, then there's a couple of different penalties that might apply. And so the first one I'm going to talk about is the $2,000 penalty, and this is the worst penalty. There's a $3,000 penalty. It sounds like more, but it's less. So this one is, this will apply anytime that you don't offer coverage to 95% of your full-time employees. And now we have an expanded definition of who's a full-time employee. So you do have to at least make the offer of coverage. They don't all have to accept it. And if you fail to offer coverage, then you will pay a penalty of $2,000 multiplied by every one of your full-time employees minus the first 30 full-time employees. So there's a little bit of an ease in there. And one of the reasons why this penalty can be sort of a gotcha type penalty is because the definition of who's an employee is going to be construed strictly. I might have a slide on that or two. Let me see. Yeah. But it's easy to make mistakes. It's easy to categorize employees as independent contractors, or maybe you use a temp agency, and if that's not done properly, they could be considered to be your employees. And then there's these kind of complicated controlled group rules. If you're affiliated in ownership with some other entities, you might have to include their employees as well. And if you're not offering that coverage, you can get stung with this penalty, even if you miss it by just a couple. The second penalty for large employers is this $3,000 penalty, and the $3,000 applies if you don't offer coverage that's affordable. And by affordable, they mean that an employee can't pay more than 9.5% of their household income. So the difficult thing for employers, of course, is that they don't know what any employee's household income is, and it's probably not a good idea to ask because A, they won't tell the truth, and B, they'll consider you prying into your affairs, and if you have to terminate somebody for some other reason down the road, more likely than not, that might come up, that conversation. So the IRS has a rule that they allow employers to use what W-2 pay, which will almost always be higher than their, or lower than their household income, which means employers might have to contribute more. That's kind of a safe harbor. You don't have to necessarily use that approach. But if you don't offer affordable coverage, and if the coverage itself doesn't meet a certain value, it's called a 60% minimum value, which means if you have a $100 bill, you have to pay at least $60 towards that amount. Then the employee, if they drop out of coverage, they can go and apply for subsidized coverage on the exchange. And when they're applying for subsidized coverage, they'll be filling out forms, and the IRS is going to try to figure out where they offered affordable coverage. And if according to what they say, they weren't offered affordable coverage, and then at the end of the year, you will get a bill for $3,000 for that employee if they received a subsidy. Part of what you'll need to do if you're a large employer then is to maintain really good records of who was offered coverage and how much it cost them, because what they fill out on an IRS form might not be actually what you offered them. And when you get the bill from the IRS, there'll be a process where you can challenge it. So you're going to need some records in place and a decent record-keeping system to determine that. In fact, you don't have to pay this $3,000 for this employee. Yes?
Now, I just have a quick question. You talk about the penalties, the $2,000 penalty if you decide just to pay the penalty and not
Well, the $2,000 penalty is part, you can just choose to pay the $2,000 penalty and not offer any type of coverage.
Now, is that $2,000 a month, or is that $2,000 annually?
It's an annual amount, and you actually save a lot of money if you pay the $2,000 instead of paying for health insurance coverage if you're in that category. But then a couple problems with that is, and a lot of employers are thinking, why don't we just drop our health insurance altogether, pay the $2,000 penalty. The one issue, of course, is retention of your employees, and another issue is a lot of your workforce, they might be eligible actually for subsidies on the exchange, and maybe they'd even be better off, especially at the lower end of the wage scale. That's definitely going to happen. But if you're at the higher end of the wage scale, if you're 400% above the federal poverty level, which for a family of four is making about $95,000, $96,000, then you can still buy coverage on the exchange for your family, but it's not going to be subsidized, and it's going to be expensive. It might be $20,000, $25,000, $30,000 depending on which market you're in for a family of four. And then the other thing is the employer can't contribute towards that cost, at least under the rules that are shaping up so far. They cannot. So you'll be, your higher end employees, the business owners, the executives and administrators will be out there paying for this cost with after-tax dollars, without an employer contribution. Really, the only way the employer can contribute is by increasing your salary. And maybe that makes sense in some cases, but then if you look through, well, what about everyone else who loses their coverage? I mean, it's hard to know exactly what the best thing is. It's going to be different for every employer.
One note about the 2,000, he said it was 2,000 per employee and all dependents.
No, I'm sorry, I didn't mean to say that. I was talking earlier when I was talking about that reinsurance tax, I was saying and all the dependents.
Okay.
The $2,000 penalty is just per employee, and it's not done it's an annual penalty. The reason I have the 1/12 in there is that it's technically under the law, it's assessed on a monthly basis, and if you don't follow some of these administrative rules that they laid out as kind of a safe harbor, you can have employees that might be eligible one month and get a subsidy, and not eligible the next month and not get a subsidy, and they're coming in and out of the subsidy status. They themselves probably don't know that they might have to repay these penalties back to the IRS, and you as an employer might not know until the end of the year when you get the bill what's happening out there, how much you will ultimately owe. So there is a way around that, and to create some certainty about what your budgeting will be, and it requires detailed tracking of hours, determination of full-time status, and then once somebody qualifies in bucket A or bucket B, then they get to have coverage or not have coverage for what's called the stability period, and that way you can kind of plan and know who's going to be entitled to coverage or not and avoid these penalties. But otherwise, they are always assessed on a monthly basis rather than an annually basis, but you'll get the invoice on an annual basis, most likely. There's still a fair amount of, I'm going to grab my phone over here so I can kind of watch the time, a fair amount of uncertainty about these rules because they're all in proposed form. And again, one of the reasons they delayed it was because the regulations weren't ready or they couldn't figure them out. Control group, I'm going to just, if you have pension plans, you might be familiar with these. If you own 80% of another company, that might have to be wrapped into your business and count their employees as well. Who is the employee? This is a common law standard. All of you do this already for determining who's independent contractors and not for FICA, that sort of thing. It matters more now because if you get it wrong, it's not just employment taxes. You might end up being stuck with that $2,000 penalty because you didn't offer coverage to 95% of your employees. So the stakes got higher. So I'm going to run through a quick example and let me see if we have more questions here. Here's an example of an employer that provides group health coverage for 100 of its full-time employees. It currently defines as employees who work 32 hours per week. It determines that 15 employees in a separate division who work at least 32 hours but less than 32 hours. And under the Affordable Care Act, now in 2015, they will have to be offered coverage. So the options are, first of all, offer coverage to the 15 employees. If the average cost of coverage is $6,000 per employee, if that's the employer contribution per year, then the cost is going to be $90,000 per year in our example. And then the total cost, adding in the other 100 that you're already paying for, then will be $690 per year. This assumes, of course, that all of the 15 are going to accept an offer for coverage. Some of them might not. They might have other options available. So option 2 is to decline coverage to the 15 employees, and that causes this payment, the $2,000 penalty, that calculates out to $170,000 per year in penalties. And if you're still going to keep your going for the rest of your 100 employees at $600,000, this leads you to a total cost of $770,000. Option 2 is not really an option. You know, if you compare it to the $690 before, it doesn't make sense to keep your main plan going and decline coverage for these other 15 employees. So, of course, you can always terminate the plan, and then your total payment would be $170,000. That's what we were just talking about. But employees might want to be paid the difference. You might, in increased salaries, you might have collective bargaining agreements. And a lot of your upper level people might not be eligible for subsidies, so they're going to be kind of stuck out there looking for a solution for health care. This is a little program I'm having just to illustrate what's happening out there with hours. It's a little bit hard to read, but basically if you have people right at the cusp of 30 hours, you can take them off your rolls by reducing their average weekly hours by 1 or 2. And where you'd want to start are the people who are closest to 30 hours, because they're going to have the least hardship by pushing them down by a couple hours per week, if that works out. That one of the things that people have pointed out to me is, well, it's hard to manage for 29 hours because, you know, people have overtime, they have all kinds of different situations. More likely, the employers are reducing hours are going to push down well below 30 just to be safe if they really want to make sure that these groups don't create a problem. You know, here's a concept that it's a little bit risky, and that's establish a subsidiary to put your part-time employees in. And I would question whether or not this might be challenged by the IRS. But technically, even though you're all part of the same controlled group, if you're in separate controlled groups, then the $2,000 penalty applies to each group separately. So, you know, this could be a way to isolate that $2,000 penalty just to the employees of that group. And where you might see this is in a Dairy Queen franchise, for example, or in some type of arrangement where you already have structures in place, but you might talk with your accountants or attorneys and kind of plan around this as well. And then finally, you can get your costs back, that $90,000, by reducing contributions overall to your health plan by the same dollar amount, and just kind of share the pain among your employees. So I'm just going to quickly talk about the administrative scheme that I was mentioning before, and then I'll wrap it up. First of all, what hours of service, you count not only hours that they work, but also the hours for which they're entitled to payment, like paid vacation, certain Family Medical Leave Act, leaves of absence, USERA leave, military leave, and if you're an educational institution, you only measure the academic year, you don't count the break. This is what's called this is the safe harbor rule I'm talking about, where if you go back and measure hours over a period and they're considered to be full-time, then you can put them in a bucket of full-time employees or a bucket of ineligible employees for a stability period. So the rules are generally that you start with a measurement period, a look-back period of 12 months. You can use less than that, but your insurance and TPAs are not going to want you to do that, because the stability period, the period for which people are entitled to enroll in the plan, can't be less than your look-back period, and no one's going to want to do mid-year enrollments. So more often than not, you're going to start with a 12-month measurement period. There is what's called an administrative period in the middle of that, or at the end of that, of 30 days or up to 90 days, where it's like an open enrollment. And then, depending on who's full-time, after you measure their hours, they're entitled to coverage for the next 12 months or not. And then even if they drop from full-time to part-time coverage, they have to stay in the plan. And even if they weren't eligible, but they become eligible during the year, they don't get coverage for that 12-month period. So it kind of fixes in time your liability and helps you manage the possibility that employees might be on the exchanges going in and out of coverage and incurring fees that you'll get a bill for. So I'll leave this slide for you to look at. This is just an example of how hours might be counted during a measurement period. They permit you to use some shortcuts. If you know somebody's going to be full-time, you can just credit them 40 hours a week for every hour of service they provide for the week, and that way you don't have to sit down and manually track how many hours they were in, for example. If they're an hourly employee, though, you do have to use their actual payroll hourly data and basically track this in a spreadsheet over the year, column for each week for each employee, average them up at the end of this 12-month measuring period, and then if they're at 30 or below, they don't get coverage, or if they're 29 hours or below, they don't get coverage. If they're 30 or above, they are entitled to coverage. I'll talk about one more slide, and then here's the part that gets most employers that are dealing with this issue, and that's how you deal with new employees. New employees, the day you hire them, you have to make a decision. Are they going to be full-time employees, or do you not know that for sure? And if you're not sure if they're going to be full-time employees, if they might be part-time employees, or maybe they're seasonal employees, then you don't have to add them to your plan as full-time employees. Instead, you begin to measure their hours going forward. And again, I would recommend a 12-month measurement period for that. So assuming you classify them as what the IRS calls variable hour employees, then you measure their time going forward, and if they are full-time employees after 12 months, then they get to participate in a stability period for 12 months. Why is this so complicated? It's because you're going to hire people all throughout the year. And there's a rule that says you can start on the first day of the calendar month after they begin. But that means you're going to have to be managing 12 calendars if you hire people all throughout the year, in addition to this other look-back calendar that we were just talking about, and tracking their hours of service. Yes?
Do you have to track their hours of service at their hourly, if you're declaring them as a full-time? Do you have to bother to do that?
No, if you're going to declare them as a full-time, you do have to maintain a record, but the record, you can just say, write down 40 hours per week. You're using the so-called week's works equivalency method. And so, yes, you will have to, you have to have the paperwork when the IRS comes knocking, but you don't have to actually manually track all of their hours. So there are some shortcuts. So here's kind of a busy spreadsheet, and let me walk through the example, and then I'll just open up for any questions. In this case, our employee is John Anderson. He has an initial management period or measurement period. In my example, I'm using 6 months. You can use a lesser amount for new employees. So he's a brand new employee, but he has been determined to be either a variable hour or a seasonal employee. They don't know if he's going to be full-time. And he's starting on September 1st of 2014. So that represents this blue period. So for 6 months, they're measuring his hours of service. And as you can see up here, they determine that he's working an average of 31 hours per week. So after that administrative open enrollment period, that's what the yellow block stands for, he's entitled to stay in the plan under this policy for 12 months. That's that green bar as a full-time employee, because he got over that 31-hour hump. Now the employer has their standard measurements for ongoing employees, and that actually starts a month later for this employer. They use 12 months, and they begin to measure John's time again. It's overlapping a little bit here. So they start October 1st. They go all the way through September 30th of 2015, and at the end of that period, they find out that John only worked an average of 29 hours. So after an administrative period of a couple of months, they give him the bad news, and he's out of the plan for the next 12 months. But the complicating factor is that, well, actually he gets to stay in the plan up here because he met that first measurement at least until March 31st. And then he's out of the plan for the balance here. More likely than not, he'll get a COBRA notice up there. That's another series of measurement periods they're going to have to deal with. And then the measurements start all over again. So if you imagine this is just one employee, if you're hiring a new employee every single month of the year, or more than one employee, you're going to have a complicated program like this to track all of their hours and then compare them to the measuring of your ongoing employees. So this is the safe harbor. If you don't do this, you're not required to do this. You don't really know what your employees are doing that aren't taking coverage. Maybe they're out there on the exchange incurring penalties because they're getting subsidized. Maybe they're not, but you'll get the bill at the end of the year, and it'll be very difficult to budget and plan for it.